So thanks very much to Conflict Dynamics for facilitating these kind of get-togethers, and to those of you who are here in person and online. Okay, so over to our topic. Well, next I must introduce and I don't know how much introduction I need to do to Judge Davis. You very relaxed appearing in front of the television cameras and the like. So I think a hybrid webinar be not one of the big a big challenge for you. But I have to say that you've been one of those academics and members of the legal profession and the judiciary that have had a huge influence across so many areas, and we're delighted to have a chance to engage with you about mediation in the civil justice system, which is what we are primarily concerned about today. So thank you very much, Dennis. Thank you for joining us. So the topic, mediation, as we know, is sort of deeply entrenched and its value well recognized in some areas of dispute resolution. And those areas most obviously are employment or labor dispute resolution, where they've been used for many, many years and are firmly entrenched in the statutory dispute resolution system. And then, of course, in family law, where very particularly mediation is important, where children are involved, but not only, really an area of conflict or dispute where relationships are very important and mediation is well known. But when it comes to commercial dispute resolution, for one reason or another that I hope we're going to talk about, it's sort of less well used. And that seems to me really cuts across the whole range of different kinds of disputes that find their way into the High Court under its jurisdiction. We had Rule 41A, which mediators have spent quite a lot of time talking about. 41A saying, that every party has to, before suing out, just lay out their stall or put their stance on mediation. And we thought that might have a big impact. But most consensus seems to be that it's had very little impact. And in fact, I've heard some people even suggest, well, it's too strongly stated and it should be watered down, which is surprising to me, because in the UK this year, under their civil procedure rules, for the first time in about 20 years, they've ratcheted up the pressure from judges making sort of strong recommendations to now being able to order mediation. But when we're looking for causes, perhaps about what is it that, what's the reason why a mediation hasn't sort of taken root as would like to think it could in the High Court litigation, I think that there's some hard questions that we need to ask, perhaps as mediators, to look in the mirror. Are we good enough? Do we actually have a strong mediation profession? It's a credible offering to parties in civil litigation. Are judges doing enough, and could they do more? Is the statutory system needing more work? There may be multiple factors. And I guess that really, Dennis, just leads to an opening kind of question, which is, what on earth is going on?
It's interesting you say that, because I'm not sure if it's finished yet, but I know on Monday, SARS, well, let me go back. I consult for the commissioner as a sort of kind of de facto general counsel. And we had a very complicated transfer pricing case. You don't need to know about tax. It's not my purpose here this afternoon. But it's a complicated transfer pricing case, a large operation, which would require huge amount of economic evidence to be given. Because just to put it in context, what this means is that SARS say, when you have a series of trademarks, etc., which locate conveniently in low tax jurisdictions, are you charging enough for a royalty, right? Which would, of course, would reduce your profit in South Africa, push up the profit in the offshore jurisdiction to the convenience of the group and the inconvenience of SARS. Now, in order to litigate these cases, they go on for weeks, and you've got to really spend an incredible amount of money getting top flight economists to be able to tell the court what's the appropriate royalty in this context. And we had a long set of conversations about this at SARS, having a transfer pricing case not that long ago. And my advice, which was taken, is, can't we mediate this? So there was sort of some silence around the room, and they said, well, how would you envisage that? And I said, well, obviously we have to ask the other side, whether they're prepared to which the answer was, well, who should we get as a mediator? And I had one person in mind who was a very top flight silk, who everybody recognized, who does do some mediations in the commercial arbitrations. But he's our man. And I know that the mediation took place this week. Now you may say, why would one advise to do that? Here is a problem where you can't arbitrate because tax cases have to go to the courts. Right? You can't go to private arbitration, which to some extent would partly explain the fact of what's going on because of the fact that so many, almost I would say 70%, maybe more, of commercial cases are being arbitrated, either by retired judges or silks. And there, things go quite quickly. So if you're in an adversarial position, you'll do that. But tax, you can't do it. So you've got to go to court. Why was the mediation, this relevant to a broader question, Chris? Partly because of a lack of confidence in the judiciary, the feeling that, we're getting very strange judgments in tax cases out of the judiciary and are becoming a roulette wheel. Two, because even if you win at the tax court, you may still find yourself going to the Supreme Court of Appeal and the Constitutional Court, which means the case takes forever and the costs are enormous. And so the idea to mediate this was, let's have a throw of the dice here, because if we can get X revenue rather than X 50, it's a win. There's certainty we get on with we can use our resources elsewhere. And I think it's a good case study of what the mindset may be. People don't think of mediation in the case of commercial cases. And I'll give another illustration in a moment. But if you think rationally, why would the South African Revenue Service and a large corporation decide to spend 3 or 4 days, whatever it is, trying to mediate this case? Because actually it makes commercial sense. It really does. And it gets the thing out of the way. And there's no adverse publicity, which is not an unimportant feature, that when a large corporation has been taken on by SARS, ordinary people may say they're trying to finagle the tax system and therefore us. So it's a win-win. And I think that what's happened is there's an increasing problem because, as you probably know, it now takes you 5 years on a trial to get in to Gauteng High Court, probably 1.5 years here. So the question is, some alternative dispute resolution is a no-brainer in that situation. The problem is that people haven't got their head around it. And to give a personal story about this, I was asked about 18 months ago, would I mediate a case between the Competition Commission and one of the large supermarkets? What had happened here was, as you may know, there was an inquiry, a market inquiry into supermarkets in South Africa. The reason being that if you put up a shopping center, Pick n Pay or ShopRite Checkers or Spar go in, they want an exclusivity agreement, which means the poor person who's selling coffee or biltong or sandwiches is not allowed in. And if you're in a context of an economy where you want to promote small and medium-sized business, particularly for historically disadvantaged South Africans, that's a massive obstacle. So the market inquiry came out with the fact that you people are in breach of your constitutional obligations or your competition obligations because effectively you're involved in exclusive dealing, preventing competitors coming in to an essential facility. Cut the story short, the one supermarket group was not prepared to settle. There were certain complications in their structure. And they were now going to take the market inquiry decision on review to set it aside, because the commission had given the indication that they were now going to proceed to enforce the market inquiry and therefore seek to hold the supermarket in breach of the Competition Act, which of course would also have triggered off considerable damages. So they phoned me up, and I'm telling you this, you must be crazy. I mean, how are we going to mediate this? They said, well, that's why we're phoning you. So I said, well, I've never done one of these things, this particular kind. In the old days, I was reminded I was part of IMSA, but that's a hell of a long time ago. And I certainly have never done a commercial mediation of this kind. So they said, well, would you be prepared to try? And I did. Now, it took a hell of a long time, much longer than a mediation would normally take, because they were shuffling backwards and forwards and meetings, and they had to go back to their various shareholders and stakeholders and God knows what. But after about 12 or 14 meetings, taking less than a year, we got a settlement. And both sides walked away very happy. There was an agreement that certain disgorgement of shares of stores would take place, and that the rest of the competition commission would walk away. They shook hands. Everybody was happy. I learned two things. The first is that it's very possible. No question. Well, three things. The second thing was it took time, but it was bloody cheap compared to what it would have been in the normal course of events. And secondly, in relation to that, it meant that it's still far more expeditious than the possibility of the tribunal, the Competition Appeal Court, and the Constitutional Court. And the other thing I learned, and here's where the mediation role comes in, that it helped enormously to be knowledgeable in the field. Because what would happen would be, I mean, obviously I couldn't express a view, but every time I asked one of the parties a question, you could see them thinking, he thinks he don't have a good point in this thing. When I spoke to them afterwards, they said, dead right. Every time you asked us something, our lawyers started thinking, have we overreached here? And that allowed all sorts of debate to take place that otherwise wouldn't have. And the long and the short of the story, Chris, is that I learned from that experience that I'm amazed many more cases on being mediated this way, and I can only subscribe to the view it's because people haven't sort of cottoned on to what I didn't know about myself when I got involved in.
Thank you so much, Dennis. I mean, there are multiple things that come up. Two that immediately strike me. One is that your SARS example is an indication of an area where parties don't intuitively think about, or would think if you were going to make a list, they would say, oh, labor, matrimonial, maybe some shareholder disputes or something. They wouldn't think of that at all. But it's interesting that you say actually maybe where you least expect it, or certainly where you don't expect it, you might find mediation useful. Second thing you said, I think in relation to that one, is that where there's parties are commercially minded, for some reason, lawyer litigators seem to think that when a matter is a big commercial matter, for some reason, the law courts are better suited at determining it. But in fact, a commercial decision may very well be dictate early settlement with money in the bag, as you describe it.
Absolutely, because I think for me, if you ask me after sort of a quarter century on the bench, what are the cases that troubled me the most? They weren't intellectual disputes, they weren't constitutional ones, and they weren't even commercial ones. They were family disputes. The question is, how the hell do you decide as a judge to whom the children should go? Right? I used to say to parties, why do you think I know anything better about your children? I have enough difficulty with my own children. Why do you think I've got any greater wisdom than you have? And those disputes are enormously, much more complicated than me coming to you, Chris, and saying, we've claimed 100, right? We'll settle on 50. And you say, go away. And you start debating. And eventually we settle on 62. That's much easier than having to deal with the complexity and the psychological complexity of things. But we don't realize that.
So commercial disputes actually are particularly suited because the parties are sitting, ultimately, they should be weighing up time, the time value of money, and those kind of considerations without all of the deep sort of emotional trauma of a relationship dispute. I mean, that's an interesting proposition because we often say that mediation is particularly suited where relationships are important. In fact, it may be more efficient where relationships are less, at least when they're fraught or strained.
I think they are. Sorry, let me not be misunderstood. I don't think that family disputes should not be mediated. I think they should. And frankly, your point about Rule 40 and the problem about actually getting people to mediate cases is incredibly correct but problematic. I mean, the amount of cases I've had where I've had to be dragged into court, and eventually, if you're an astute judge, you start mediating this yourself because you know that it's actually going to be. I mean, again, just anecdotally, one of the things that if I ever wrote a biography, I certainly put this in it, which was that I had a case where the mother and the father are arguing like hell about the typical weekend transfer, and it had great. There'd been all sorts of mediation about this, and the mother now had come to court. The father had come to court to get an order locking up the mother for contempt. So I speak to the parties and try to sort of mediate. I get nowhere. I finally say to them, how old is the little boy? They say he's 12, which at that stage was my son's age. So it was about 20 years ago. So I say, I want to see him. They said, you can't see him. He's just come. I said, I want to see the child. Sorry, you want something. So the child arrives at school. You can imagine, last thing he wants to do, kick the parents out. I say to the child, I'm hell of a sorry, but I have to ask you a few questions. I said, well, have you just come from school? Yes. Have you had lunch? No. Would you like to have lunch? Yes. Would you like to go to the Spurs? So I march out with him to the Spurs. My colleagues greet him as, hello, Joshua. They think it's my son. We go there. After one John Lee burger, he tells me everything, which is basically that he doesn't want to go to his father, because if he does, he has to then play with his step sister, and what he wants to do, as he does every Saturday, is to go and surf at Musenberg. And frankly, I came back, said to the father, you're a shit father, this is what should happen. And that's what's now going to happen. Father was, totally taken aback, finally had to agree. Met me 6 months later, he said, I'm so grateful that you did that, because if we'd gone to court, it would have just been a mess. I now have a good relationship with my son. So I'm not saying mediation in family disputes aren't important, they're vital, but I think they're more complicated for me, just as a human being trying to do them, than I'd find even trying to work out between the competition in a large supermarket.
So, Dennis, what is it that is causing? I mean, you've given 2 examples of large, multifaceted, multi-issue, multi-party disputes that, intuitively people think are very difficult to mediate. And even though one took time, they seem to be very suitable. So what is, is it, you said people don't think of it. I mean, there must be more contributing to it. And partly we're always interested in the antidote. We're interested in what we can do or should do to try and drive change. So what is the cause of that? Why is it? What's the reluctance? And I'll put 2 reasons that are sometimes noted, one of which is that attorneys, perhaps, are said to be inadequately, not to properly understand mediation, and sometimes to pursue their own interest and to feel that settlement of matters takes away their bread and butter. It's a horrifying reason to give, but it's frequently raised. And the second one is perhaps pointing to counsel that simply think that mediation is almost kind of violence to that vital search for the truth and the win that you're always looking for in your practice.
Yeah. You've touched on, I think, central features. So let's just reiterate those and then move forward. I think the adversarial culture that we have in our legal profession is such that people recoil against the notion of sitting down and rationally trying to debate an issue out. I think, the sort of idea we're going to beat the hell out of them is so ingrained. I mean, you're somewhat different because you involved in mediation, etc. And I'm not complimenting you, and it's true. But the vast majority of litigators, they don't see it that way. And eventually, for me as a judge, I've often wondered who's driving this, the client or the counsel or the attorney? Because, the old trick that you try to do is you go into court and you look very, very sternly at the client. and you say something along the following lines. You know, judges do strange things. Sometimes they find for you, sometimes they don't find for you. Sometimes they find for you when your counsel doesn't expect it. Sometimes they don't find for you when your counsel expects they will. Just say so. So, do you want to take that chance? Or shouldn't I adjourn for an hour that you can actually talk about this? And you can bet your bottom dollar in 95% of the cases, the client will look at their attorney and the attorney will say, stuff him, and off we go. We're going to, because we've prepared, because, there are big fees and all this sort of stuff. I mean, I'm afraid to say the adversarial legal culture has a series of consequences that you've tested, that you've spoken about, and I think that's absolutely right. And I think in counsel's case, that is also correct, because they prepare for the case, and I suppose they prepare to take a big collapse fee. But the bottom line is that that's what they're not comfortable. It's not the expertise to mediate. Their expertise is to bash the other person over the head, sort of thing. So I think you're right on both of those. I think judges are not particularly good at this either because they come from a similar culture. So instead of basically insisting that you go away, I'm not going to hear this case. I'm just not, I've got the file, I'm going to hold on to the file, but I'm sorry. I look at this case and there's no reason why you people should not mediate this. I can't tell you what the settlement should be, but find yourself a proper mediator and let's get on with this. Judges very rarely do that. Right? And they need to more. There are other countries that do, as you know, and I think they should. And then I think, as I said, fourthly, I think we don't have the, and I plead guilty to that. I certainly didn't have the imagination to think that mediation was anything outside of labor and family. And those departments are not out. So there's an educative feature here. And I will tell you this, I found it interesting, not because of my experience, but out of the blue. And I'll mention his name because he organized a seminar on this. Anthony Norton from Joburg organized a seminar about whether one should mediate competition cases. And he was right. So let me give you an example there. So there's this massive merger now with Vodacom, which was turned down. Consequences are just enormous. I need to shut up about it because I may have to hear the case. I'm not talking about the merits. Think about the fact if good sense had prevailed and you'd had some sense attempted mediation in the Competition Commission and the parties to see whether some conditions could be crafted, etc. They took 3 years to investigate this the thing. If they'd simply sat down and tried to mediate it, and they have failed. But it's worth the shout. And so I think increasingly we should be making people aware of this. That's what Norton was trying to do. I don't know what's happened with it, but that's what I think there's a massive lack of awareness as well, Chris.
Well, you've touched on a different point, a further point that I've heard very often raised by lawyers and counsel about where mediation is not appropriate is where you're dealing with public authorities. Somehow the idea is that, ultimately government has to be, where government is being held to account, it has to be done ultimately through court decisions, or where social services or social goods are being delivered by the government, those kinds of matters can't be resolved
Possibly
by consensus.
Well, it may be. I mean, it may well be because you may get a situation whereby, a party's demanding X, government says it can't do anything, right? And you sit down, start thinking about it, and you may be able to craft some order, which essentially has a progressive realization of something, or alternatively, where some form of settlement gives the parties time, or whatever the case may be. But I mean, really, at the end of the day, how many of these cases are satisfactorily resolved through courts? I mean, the time period is just astounding. Again, taking the competition field. I mean, let me give you a fabulous example. In 2018, the Competition Commission of South Africa basically lodged a series of complaints against about 25 offshore banks, right, etc. The matter went to the competition tribunal, which sort of found that some banks that there was jurisdiction against some of the banks. It's not totally relevant to what we're talking about in Labour, by the way. And for the vast majority said they hadn't set up sufficient facts to ground jurisdiction. Matter went to the Competition Appeal Court. I gave a judgment on behalf of the court, which basically said you can have jurisdiction, but not on the basis that you pleaded it. You've got to go back and plead it. They went back and pleaded it. They went to the Competition Commission, and that was appealed to us last year in 2023. The judgment was given in which we said, yes, you can go against 5 or 6 banks, but the rest of them, there's no cause of action. Out goes, exceptions upheld. They've now appealed to the Constitutional Court, which is going to hear the case. Case will be heard, luckily, if they're lucky, sometime in 24. By the time they're finished in 24, right, if you know the Constitutional Court, you'll be lucky to get judgment for the end of 24. So now, assuming that the Constitutional Court now says, yeah, fine, right, they all should be stand trial, right? Can you imagine, firstly, all the discovery and all the other stuff? So that'll be 26. So if you're lucky, you'll get into the tribunal 27. Now, the case will go on forever. By the end of 27, the tribunal will perhaps have given a determination, and they'll appeal, the aggrieved party will appeal to the Competition Appeal Court, which will hear it in 28. Again, the aggrieved party will go to the Constitutional Court, and if you're lucky, the matter will be completed by 2029, 2030, 12 years later. Now, I only have to state that to say it doesn't matter whether you're a public authority. That kind of case cries out for a different form of dispute resolution.
It's a wonderful career for the lawyers in that area.
Oh, they make so much money, they don't know what they do.
But I think it does, I mean, to me, it does make the point that even matters where public authorities are needing to regulate, actually the idea that these sorts of things play themselves out like that, it can't ultimately be efficient or effective regulation.
My point entirely.
Yeah.
So the question is, what other mechanisms do we have in the toolbox? Now, if you've got a proper mediator in there, you probably would have struggled to accept, but it would have been worth a try. At least this, it may have narrowed the case down. It might have, all sorts of things might have happened. All I'm saying is that I don't think every public law case can go to mediation, but I think there are tons of them that can.
Thank you very much, Dennis. I wanted to raise a slightly different point, and that is about counsel, sort of a species which you referred to briefly. It's generally adversarial, and they plan a case and aren't comfortable in an environment of sort of showing a bit of give and take and that kind of thing. I don't think that's inherent in the profession. And I say that anecdotally. I think one of the first mediations I did after training as a mediator, I went as an observer in a mediation in the UK, where counsel were very much present and part of the mediation, and were very helpful in reality testing and helping the client do their own risk assessment and that kind of thing. So that seems to go more to a culture rather than the nature of the profession. I don't know if you have any views.
Well, I'll say this. In the case I was talking about, the Commission's case, the Commission represented itself. What was interesting, in the first iteration of meetings, the other side had 2 silks, very good ones, I might add, no question about that. They weren't uncooperative, but I noticed that as we moved through the process, maybe because of costs, etc., the attorney on the side of the supermarket chain was together with her assistant, were the 2 people around the show. Obviously, they're counsel who's sensible enough to be in mediations, because there are lots of sensible counsel who know the weaknesses of their case. And so in a mediation, they're not unhelpful, because they can say to their client, if we don't settle on this point, I can't guarantee, in fact, more than that, we may well lose. So they're quite good at evaluating the chances. And so I'm not excluding them. I think to a large degree, their training eschews a thinking that almost your default position in this kind of case would be to seek some alternative approach as opposed to simply rushing to court.
On timing of mediation and when in the evolution of the life of a dispute mediation might be most effective, it's a common complaint of writers on the topic that lawyers will tend to get into settlement very late after all the legal costs are sunk. But I can also imagine that counsel and attorneys who've planned a case and prepared it and they've got their day in court would be a little upset if, as they about to call their first witness after carefully planning this thing, the judge says, I'm directing you to go to mediation. I'm not going to hear this. I can see somebody would say, but that's not efficient either. But I did read, apropos of the changes introduced this year in the CPR rules in the UK, that the possibility of a court having the power to direct mediation causes parties to choose to mediate much earlier in the process, because nobody wants to be in that position. And because they know the court has the power to direct them to mediate, they are more inclined earlier to say, let's have a proper crack at this at an appropriate time, so that we don't run into a situation where we haven't exhausted that possibility. We're about to run our case and a judge directs us to mediate. Any thoughts on that?
I think the South African context is somewhat different, because I think, I'm speaking out of turn, I think it's absolutely clear, go and ask anybody at the bar, that the problems of the judiciary are such that outcomes are far less predictable than they were before. If you got a predictable outcome, you may be reluctant to go to mediation because I know I'm going to win. I mean, there are cases where I've got precedent on my side, the facts on my side, I know I'm going to win. And if you want some, bull duster opponent who's just taking a chance on the other side, I not want to mediate, because it may actually be that it's clearly in my client's interests. But increasingly, which was the story I told about the tax, people are no longer certain at all. And I can't tell you the stories about, people going to court and going before a judge. A judge asks some ludicrous question. There's a request for an adjournment. They tell the judge the case is settled, and they rush off to alternative dispute resolution, mainly arbitration. But what I'm saying is that I think the instability of the South African climate, together coupled with the fact, particularly in commercial matters, where we have a dearth of skills on the bench, everybody knows that, together with the fact that you've got long running waiting lists, seems to me, Chris, that here, I think even a sensible counsel, not such a sensible counsel, would be more amenable.
I mean, I want to come to see if there are questions from the floor, and encourage you, if you haven't thought of any yet, or if there's anything on your mind, be free to jump in a minute.
So the question is, how would a mandate to settle in a public authority mediated matter be achieved? And that question was from John Hutch.
So how does a public authority get a mandate to settle in a case where it's vindicating statutory? I
mean, come on. I mean, the amount of cases I've dealt with where the public authorities either agreed to a court order on a particular basis, happens all the time. They get authority from whoever the public authority is, mandate the clients accordingly, and off we go.
Yeah, I mean, it might be the question comes, there are two nuances to that.
It may be that there's a FMA or other kind of problem in relation to money. I accept that.
Well, so I can see two. One is, I've had practical experience advising public authorities where actually, and this is more of a, I don't know if you'd call it a policy or a personnel problem, which nobody wants to stick their neck out and take responsibility. So they won't write the right memorandum, they won't get the right advice, and they won't get the person with authority to make the call, because the person with authority is just not prepared.
Coupled with the inefficiency of the state attorney.
That kind of thing. So that's a sort of an efficiency problem. I think the question might be pointing to a situation where you're under a duty as a public authority to vindicate a right, or to pursue a point. You used the point about under the PFMA to recover. How do you settle? But I have to say, I agree with you that even in those circumstances, public authorities must make rational decisions on limited resources, and they have to decide.
Absolutely. They can say, we'll engage in mediation here, because quite frankly, it's tying up too much of our resources, and it's our fiduciary responsibility to the authority to do the following. I honestly can't see. I can understand the difficulty of getting instructions from time to time. That I can.
It's a practical and an efficiency problem. It's not a conceptual problem.
I understand that, but it's not a prohibition against dealing with it. sensible authorities maybe will be amenable to do this.
Yeah. No, okay. I think that that's. I hope that answers the question. Brett, yeah, that worked so well. So if there are others, will you just jump in and tell us what they are?
So Londiwe had a question, Chris. How do we encourage a mediation culture within competition law, especially with the backlog faced by the competition tribunal?
That's a great question. And I think the answer to that is I can't tell you who made the overture in the case I was involved in, whether it was the commission or the private party. But I think what happened here, if I'm right, and I speak subject to correction, that the attorneys for the supermarket made that overture, and the commission said, "Why the hell not?" So really a question of speaking to them, and the backlog is so enormous at the moment, and you are not getting decisions through the tribunal. And I would, there's an aspect here which is not unimportant, which is that if you take the Competition Commission's mandate, it should be to facilitate economic intercourse in the society. And the longer that the cases got clogged up in the system, it's to the disadvantage of the economy and economic growth. So I don't think they'll be totally, it depends on the sections. I suspect the cartel section, from my experience, will be less reasonable than the merger section. But I think it's very possible. And it was interesting, this was a case, obviously, on abuse of dominance, and the people running the commission were perfectly, and the fact that they've done this once indicates to me that they'd be amenable to do it again because they were very pleased with the outcome.
I mean, it does seem to me, Dennis, that as a general proposition, this is focusing on the public regulatory authority. We have this idea that it's possible or conceivable that the public authorities tasked with different areas of regulation in our society are capable of seeing through and enforcing and securing compliance with all of the regulation under their purview at all times. And that seems to me to be an enormous myth. And that, in fact, at any one time, a regulatory authority in our society, no different in the United States, is going to be making strategic decisions about how to use its resources and what it can and can't, where it can and can't put them, and what's going to drive the greatest benefit or consequence for under their mandate. If that's right, then that seems to me also an answer about why they must, whatever you're regulating or responsible for, must be eminently capable of being, resolved by agreement.
I agree. I think the implicit thing of your response and the question that it is, it's a process of education. It's a question of getting out there and informing authorities and informing the broader litigating community that there is this possibility, that it's a hell of a lot more expeditious, cheaper, and maybe more effective, and it can be done. I don't think, all I can say is, maybe I'm actually wrong, Chris, but if it hadn't been for the fact that I got that call, I would never have thought that mediation was possible. I would never have spoken to SARS about the possibility of them doing a mediation. And all I'm trying to say is it does seem to me people are in their kind of little prisms and they don't really go beyond that. If one can broaden their gaze and say there is this and it can be done here, I think that you've got to educate people. You might want to educate the attorneys and educate the legal profession in particular. You may want to have a seminar with a whole bunch of them to talk this through, because, that's the way they may start saying, well, we don't want to be caught out here. The last thing they want is for you and your firm to be successfully doing this, and then the other firms aren't doing it. And the question is, well, how come they're doing it so successfully, and you've charged a huge sum for litigation that still hasn't ended?
But that's using competition to drive a demand for mediation.
Competition is always a feature here. Yes.
Yeah. I just want to return to another topic. Since you're a judge and you have handed down many, many judgments, Dennis, and I assume when you write a judgment, the answer is the conclusion is correct, just, equitable,
One tries,
and provides the right answer. But there does seem to be something of a myth. I read an article written by Louis Harms many years ago, actually, about the imperfections in the adversarial litigation system, and he was comparing them to continental jurisdictions, even in criminal law, of a more inquisitorial judicial system. But one of the points he made is that, and I don't know if that's a myth that the legal profession and the judiciary expect the general public to accept, which is that there is a truth-finding exercise in which equity, justice, the right answer is eventually delivered through a judicial process. Now, you mentioned challenges about, quality of the judiciary. If I was a judge, would I have enough commercial nous to deal with the cases that came before me and so on? So there are always challenges with the judiciary themselves. But even in I question whether in theory even it's possible to have a dispute resolution system that delivers the right answers all the time.
When I was in practice and a client came to see me and asked me the question, so what's our chance of winning? So you see all those law reports there. One side won and one side lost. And in many, many of those cases, the side who lost, represented by the most distinguished counsel in the country, or certainly one of them. And the answer is you can't be sure because there is no one right answer. Let me try to put it this way. I think there are cases where there are right answers, obviously. If you have a situation that you've got a will which is invalid because it only has one witness and there should be two, that's quite easy to deal with. Right? And so lots of cases, which, to be honest with you, why people litigate, I haven't the slightest idea, because it's a loser from the start. But the cases which really you're talking about, which are many, and which generally do find their way to the high courts and further, are cases which I call the 5149 case. So you sit there as a judge. I understand your argument. Your argument is not an implausible argument. It's not an argument that I can say that's complete rubbish. I think it's an argument where you say, the other argument's a better argument.
51 or 41.
Yeah, 41. Now you go on appeal, the Supreme Court may turn around and say, no, the 49 argument is better than the 51 argument. And they reverse you. So the complexity is, if you think that judges are a slot machine, where you simply put something in the machine and out comes the correct answer, that's rubbish. It doesn't happen that way. Which is why we've got so many appeals. And why even when you get to the highest court in the country, right, how many times have you read that they've got horribly wrong? Because people think that that shouldn't be the right answer. There's no guarantee here, with the best judiciary in the world, that you're going to get it right. To be sure, given the levels of appeals, generally many cases come out probably on the right side, but they're hugely costly to get there. And to be honest, there are numerous cases in which people make mistakes. I mean, you only have to look at research dealing, for example, the United States, America's criminal justice system, to see how many innocent people are actually in prison at the moment, right? Because there were judicial mistakes. And so there's no guarantee. The idea I want to go to court to find the truth, that's just a figment of ideological imagination which keeps us in business.
Yeah, I mean, just to reinforce that point to some extent, and I think it might have been Harams that first got me thinking about it, that the idea that a counsel who's carefully planned their witnesses, and in lawyer-driven trials in an adversarial system, there's a careful choice made about what evidence is going to be put in front of the judge, how it's going to be presented, and what questions are going to be asked to challenge it. And the judge is actually expected. I think you might be one of those judges who speaks his mind and asks his questions in court. But there's a general expectation, actually, that a judge will largely be detached and observe and assess what is presented to.
Well, because you're only getting a partial narrative as the judge. So let me give you an example of a case again, which I was involved in, and which I think I can speak about quite a lot, because the particular individual concerned who was involved in the case did. This was a case dealing with Marcus Jooste. Right? It was a tax case. And he gave evidence in front of me for 3 days. That itself was very illuminating, because at that particular point in time, Mr. Jooste was regarded as the great businessman. And I made a fatal error. I didn't make a credibility finding against him, which I should. I thought I could find against him on the basis that the law indicated that he wasn't entitled to treat the particular accrual as a capital one. So I did. I was overturned on appeal. Went to the Supreme Court of Appeal, they overturned me, as did the full bench. If you ask those judges now, they're somewhat embarrassed about that because they obviously were captive of my mistake that I should have found a credibility finding that he was lying, which would have then solved everything. But they now know, as do I, what the truth really was, right? The fact of the matter is, you don't have that all, and then judges make mistakes. I certainly should have made a credibility finding against Jooste. I didn't do so. That was fatal. The fact that they didn't, that none of us had the full picture of what kind of human being we were dealing with, again. So the answer is you only have a narrow narrative. You have the file in front of you, you have the evidence in front of you, and you did right. A shrewd counsel may ensure that all the weak witnesses who basically would give the game away are never called. And the other side may be bad at cross-examining. I mean, that's the other thing. I mean, you can get a witness who probably under various, Sydney Kentridge or Wim Trent was cross-examining, probably also didn't come out. But 95% of the run-of-the-mill counsel don't get there, and the judges are captive of that.
So we agree it's not a perfect system. It's
No,
quite
it's
a
a
blunt
totally
instrument.
imperfect system.
Yeah. Are there any, Brett, any other questions on the chat that we can put to Judge Davis while we have him captive? No, it doesn't sound like it. Anybody from the floor? Yeah, Tony.
Yeah.
So I've got a question more. We've been talking a lot about process, and I'm thinking of the people, the mediator, as a person, and so there's an acceptance process, but also parties accepting who would be a good mediator. And would that be a judge? Would that be counsel? Or would it be those trained in mediation? And attached to that would be, you mentioned, for example, having tax knowledge in the transfer pricing matter. Is it necessary to have those deep type of understanding of the issues at play to be appointed as a mediator?
Great question. I think the sine qua non should be that you have some training in mediation. I mean, you can't just, there's a skill here. I don't tell you guys. I mean, you know more about this than I do. I mean, there's a skill in mediation. You can't just walk in like a blunderbuss. And the idea that, you're not there to give your view as fantastically important as you think your view is, but subtly relevant to the process. So the skill of obviously having skill in mediation is terribly important. But with complex kind of commercial cases, it's probably true right across the board. If the party, even a family dispute or a labor dispute, with the mediator, the parties know the mediator's been around the block a few times, right? They know all the tricks and the rubbish, right? They can ask the right question in the right nuanced way that helps. And obviously it does help. I can't deny this. That certainly my experience of doing the competition was having real knowledge of the field, put the parties on guard, and certainly just simply the way I framed the question to them made them think maybe we're overreaching here. But I don't think that the sine qua non, because I think even without specialist knowledge, if you're an experienced mediator, you probably can get there, maybe 5 minutes later, but you'll get there. So I think it may be, if I could put it this way to you, that if you're going to launch into commercial mediation of complex kinds, it may be that to start with, you've got a mediator who perhaps does know something about the field, which will give people greater confidence in the process. But it's the process that wins the day, not the individual.
Just attached to that, then, is almost advice as to where mediators should play, because it may not be at the most complex level But maybe, given how clogged the courts are and process, to be able to clear the easier matters and be able to meet those and find a place for mediators.
Oh, it doesn't have to be with it doesn't have to be, Vodacom or the large corporations. Not at all. Of course, you did right. And it may well be in the smaller cases that it's even more important, precisely for all the reasons we've traversed. Yes, absolutely. I'm totally with you. But it's a question, if you have a party who's represented by an attorney, you're going to have to persuade them, at least give them the confidence it's worth the shot. And my own view is, if it takes off just with a few successful cases, there'll be an exponential rise in mediation, precisely because of all the problems that we've been talking about this afternoon.
Chris?
If I can just
Sorry.
yes, Brett, Brett, and then TJ.
I've got Leader Souza with a lengthy question. Just when you have the next moment, let me know. I would like to just try and give her the ability to talk because it's quite a lengthy question and it may be better coming from her.
Okay, well, exactly. That make that the next question. We've got Justine in the room that's got the mic. Carry on, Brett.
So I just wanted to make mention that Sasol, the pro bono of Sasol in the Western Cape, is in the process of putting a pilot project in place with the Labour to have mediation to assist to clear the backlog in the courts. And so we're in the process of getting that done with Sasol members who are attorneys and who are accredited mediators. Just start getting confidence in the system, because if the system is broken from the CCMA going up to the Labour Court and the Labour Court as well, just cannot cope with the kind of cases that are coming through. So that's what we are trying to do, is to assist the courts and get the mediation, even though it's in the labour sphere. We're finding it difficult to get labour practitioners to buy into it when it comes to litigation. So that's what we are in the process of getting in place. Hopefully, if that pilot works, we can then roll it out to the labour courts at least, and then maybe we can get into the CCMA as well there, because nothing's happening there. There's those conciliations of box ticking exercises, nothing's been. And then the labour courts are too long, and no one has the funding to actually do anything.
It's interesting you raise that. I can't how important I think that is. Because I've been involved in the Labour Appeal Court for longer than I care to remember, when we started, and I think my first appearances in the Labour Appeal Court, I hate to say, were about 1998, 1999, we got really complicated cases. And we had all the fancy schmancy silks. So you had sort of Trengove and Brassy and Gauntlet, and Coral Tip, Torres, and the whole bunch of them. Unbelievably fine counsel, and they were complicated intellectual cases. If you go to the Labour Appeal Court now, as I still have from time to time do, I'm dealing with unfair dismissals and CCMA reviews, where very little, very important for the parties. Let me not de-emphasize that. But you kind of think, really? This has really gone through the CCMA to the Labour Court to the Labour Appeal Court. This is crazy. And I think the bulk of the cases coming to the Labour Court are ones that could be mediated and should be mediated. And you did right. It's madness. And so I can only hope that your project works, because the Labour Court is totally clogged up and is not working at all. But I think that, that's probably true. It's interesting, because I've got a similar problem. Let me disclose. I was appointed chair of the Companies Tribunal. And it turned out that they were amending the Act, and the Act has now been amended to this extent that you can't mediate or arbitrate a company's dispute other than through the Companies Tribunal. It hasn't been taken effect yet, Chris, but it's about to, right? Now, there are two aspects to that. which may be relevant to the broader question. Obviously, when it comes in, Michael Cooper and his fancy schmancy group are going to have a shock because they can't arbitrate a dispute where the cause of action is in the Companies Act. But more important than that, it's terribly important then for the Companies Tribunal to have, and it goes back to your earlier question, to have people who the customers are confident in. Because what they will do then is to say, we now have a choice between a court that takes 5 years and a mediation process of a bunch of incompetent schlemiels who know from nothing. So we'll just sort this out ourselves, which may be a good thing, but it often won't work. So we've also written to the judges president around the country saying, you've got a 5-year backlog. We're not saying that you should hand us your company case to arbitrate, but you may want to consider using us to mediate them as a precursor. And I think that should be true right across the board. Obviously, in many areas, there's no compulsory body that has to deal with it, but it's exactly the same problem. I'm not sure how far we're going to get, but it's important.
Yeah, that's a really interesting point. So what there probably are many different dispute resolution tribunals in a similar position.
Well, we're the only one, to the best of my knowledge, where it's now statutorily obligatory to come to us.
Yeah. You mentioned the 5-year
for mediation, not for litigation. It's a different matter.
Yeah. You mentioned the 5-year backlog in the Gauteng courts, and just picking up from Justine's point, there is, as I understand it, I mean, I think after recent comments by the Deputy Judge President, I think the Judge President of the courts, Dunstan Lumber, has taken the thing by the scruff of the neck a bit, and that there will be similar efforts being made through mediation organizations to try and actually find out how do we supply the right quality mediators into the sort of system
well,
that can make a meaningful effort.
But you guys should be doing what I've just done on the companies thing, which is to go and approach the judge's president and to say, hello, we offer a service. We're not supplanting your thing, but you can't cope with this. It may well be that if we can successfully mount a mediation thing, we can take a whole lot of cases off your thing, and your judges can concentrate on doing what they should be doing, which is having a reasonable caseload, and they can get on with the job.
Brett, I did invite whoever was asking that long question to speak. Are they able to?
Yes, I'm going to give it a try. Lee, if you are still there.
Hi there, are you able to hear me?
Yes,
we can hear you, Lee.
Yes, carry on.
Good afternoon, Judge and Chris.
Hello.
Thanks for a lovely talk. My question might be a bit of an unfair one, but there are many attorneys trying to access mediation in the courts via court order. I'm aware that Rule 41A only empowers the court to instruct the parties to consider mediation. But if one looks at Rule 41A in conjunction with Rule 37 and 37A and the nature and purport of the directives that are in place, I've long believed, and I'm hopeful that maybe one of my applications will succeed, that in the context of all of that in combination and in the interests of the party's obligation or fostering the party's obligation to expedite the matter towards finalization, that possibly a court may have the authority to order mediation in that context. The problem is we sit between the devil and the deep blue sea. If a defendant, and I am predominantly a plaintiff attorney, but if the defendant refuses to mediate, particularly in Y category cases, we really are stuck. So the question is, how do we get to mediation? I was involved in 2 very successful mediation projects, both for the Road Accident Fund and the MEC, and it's been shown that it does work. I guess my question is, in the context of 41A with 37 and 37A and the directives, do you foresee a possibility of somewhere the court looking at ordering mediation? Because without it, our hands are tied.
Can I say this? When I was a head of court, because of being judge competition appeal court, there were lots of conversations about this because of comparative experience. I've never quite understood why those rules have never really been vindicated, because my reading them is not entirely different from yours. And I think the answer to that, particularly with some of the judges present, my view would be certainly talking to so. And now when she comes in, Judge Bakwana, who's taken over here, who has huge challenges of her own coming in, that if they issued a directive to the effect, that in certain of these kind of instances, some form of mediation should be attempted before they start setting matters down, I would have thought parties will follow. Now, you can get the problem that a friend of mine who's mediator in England told me, totally, I didn't realize it would be useful for this particular conversation, but he said he was in a mediator where the case had gone to the Court of Appeal, and the Court of Appeal ordered mediation. The family dispute was a money dispute. And he said they ordered mediation, and when he got there, the two parties said, we know you're going to try to mediate this, we're not interested. Right? And so they went through the sort of, the form of mediation. And he said it was obvious to him from early on. We spent a whole day, and it was obvious they were never going to settle this. They wanted to get to the Court of Appeal. So you can always subvert the system, but I think a directive from a judge president telling his or her judges, that they should insist upon this. Most parties aren't going to tell the judge to go away. To the contrary. Counsel are extraordinarily obsequious in front of judges as much as they're rude behind their backs.
Thank you so much. It's encouraging to hear. Thank you.
Dennis, so what I take from that is that there is room for improved judicial activism, for better, for stronger, more direct.
If you talk to Dunstan Malambo, and I would imagine Nwazi Bokwana will have the same feeling when she comes here, is a sense of desperation. I mean, how can you say to a party, I'm terribly sorry, but we will set you down for 1st of January 2029? I mean, that's absurd. By the way, it's also probably unconstitutional to some extent because you don't have access to justice. So if you're offering them a route out, sensible judge presidents like those two are going to seize the moment.
And it seems to me that even if you're doing that in a as you describe, which says, I'm not going to get this because it seemed to me you've tried hard enough. If that's the stance the judges take, without even saying I'm ordering you to mediate, I'm simply saying I'm not going to hear you at this juncture because I'm not satisfied.
You mediate, and you told me, and don't come back to me tomorrow morning.
And it does seem to me that might have an effect which is at least predicted. And I think it's been observed in British Columbia, for example. Tony Allen wrote about this and said that research in British Columbia had shown that point I made earlier, that if that's a serious risk, and that judges take that stance, parties are much more likely actually to make a serious attempt at mediation before they get to that position. Where
Chris, I'll tell you this. I mean, now that you trigger my memory of this, on quite a few occasions, I did the following. I said, I really want you to go and talk about this. It seems to me I'm not sure I can give you a better result than reading the pleadings than you're going to get it if you mediate. So I'll tell you what I'm going to do. I'm going to stand the matter down, and you're going to go away for a couple of weeks and sort this out. But I will hold onto the file. And if you can't, I will hear the case. And that gave them the assurance that, well, if they've got a judge who kind of knows what a plaintiff defendant is, they still got the judge, which gives them a sense of relief that you're not pushing them away. And then they've got to go through the roulette wheel again. And there was always an incentive, it seemed to me, that, if they felt, well, there's somebody here, if it worst comes to worst, you'll get a decent hearing, that they were prepared to play ball. And on some time to time, the settlements did take place. I think it does require some serious activism by the judge. And besides which, I would have thought judges would welcome that, because most judges, and I think it's, let me qualify the roulette wheel problem, is that most judges at the moment are totally overworked and under-resourced. And just to give you a sense of that, which is, I'm not trying to defend the fact that obviously all sorts of appointments have been made through the JSC that are questionable. We all know that. But if you when I arrived on the bench, my computer actually did work, and I had access to every one of the sites, the American and the British and LexisNexis and all of them. With 5 years, if my computer worked 2 days a week, that was a lot, and I had no research sites at all, and the Department of Justice was not prepared to pay for them. And do you know now that judges don't have law reports? So unless the judge has access to SAFLI, they cannot access law reports. And judges don't have clerks. They've got a secretary, but they don't have a clerk to help. There are no resources. Now you're asking a judge to decide a case where the senior and junior counsel and attorneys like yours, massively equipped, and some of the judge who may be finding it difficult to access SAFLI because its computer's broken down. It is an intolerable situation. So if you're offering them a way out or a way to alleviate that load, I would have thought most of them would take it.
Well, thank you very, very much, Dennis. I think that is time to call time. For those online, I'm very sorry that you're not going to be able to mingle with us that are here, but I hope that you'll find a way to entertain yourself for the next half hour or so while we're here. It's been fantastic to have you on this session. Thanks to those of you who've attended, and Dennis in particular. Thank you so much for coming to join us. Really appreciate it. Thank you very much.